Okay, you start. Welcome, everyone. Regarding this event, just a few procedural matters. There is an English and Greek live translation. Viewers inside and listeners inside of this room and outside of this room via a live link can choose accordingly the language they want to listen to. My appeal to our speakers is to speak normally, no high speed, because there is a live translation. And the technical matter of the subject makes it even more difficult for the translators. As far as timing, this is how I'm going to go about. Each speaker would use normally about 20 minutes and no more than that. After 20 minutes each given to the speakers, we're going to have a discussion for about 50 minutes. All right. So a few words about this event. It is indeed with great pleasure and honor that I'm hosting this event at the Parliament, the European Parliament. The role of the International Criminal Court in researching for political settlement the case of Cyprus. As far as I know, it is the first time that such a subject is presented in the European Parliament. And a few words about the background, how we got here. About 2 years ago, by the way, you may choose to listen to the Greek language if you like to. About 2 years ago, I received an email from a friend of mine, an American lawyer, Ethan Tsimbidis, who lives and does his business in Washington, D.C., suggesting me to contact Professor Gondorovic about a possible criminal case against Turkish officials. The legal case arising for committing crimes against humanity in Cyprus that falls under the jurisdiction of the International Criminal Court being Hague. Being a finance person and not a lawyer, of course, I started studying. And, of course, I contacted Professor Gondorovic with his help and advice, but also with the help and advice and support of the legal center, Shara Hadim, being based in Israel, having a lady on the top, by the way. And with a group of legal advisors, we arrived at Hague last year in July. And we filed a legal document with full evidence in the court about the illegal transfer of Turkish people from the mainland of Turkey to the illegally occupied part of Cyprus, which is under Turkish occupation. The charges included mainly against the chief commanders of the Turkish occupation forces in Cyprus. From then on, we managed to have the support of the Ministry of Foreign Affairs of the Republic of Cyprus. So with that in mind, please allow me to give the floor to Ambassador Cornelios Corneliou, representing the Ministry of Foreign Affairs of the Republic of Cyprus.
Thank you very much, Mr. Mavridis, dear Costas, esteemed professors Kondorovic and Shabazz, honourable members of the European Parliament, dear friends. It is a true honour to be here today in the company of such distinguished speakers and audience. Let me start by thanking the member of the European Parliament, Costas Mavridis, for organising this event, for his initiative to remind us all of the importance of lasting respect for and the enforcement of international justice. So we are here today to talk about the International Criminal Court and to talk about the Cyprus problem and to talk about justice and peace. Echoing the words of the former UN Secretary General Kofi Annan, justice and peace are not rather properly pursued, they promote. The question then can never be whether to pursue justice and accountability, but rather when and how. For more than 40 years, my country, Cyprus, a member of the European Union, has been the victim of an unjust division. A shameful anachronism which, despite our efforts, remains today unchanged. Cyprus, being itself a victim of foreign invasion and ongoing occupation of 1/3 of its territory, firmly believes in the power of the rule of law as the only solid answer to humanity's post-World War II promise of never again. Driven by this fundamental belief, Cyprus signed and ratified the Rome Statute of the ICC well before its entry into force. At the same time, we actively campaigned together with our EU partners for all governments to ratify the Rome Statute. In addition, since October 2013, Cyprus has been a co-focal point for the plan of action with a view to making a contribution to the promotion of universality and full implementation of the Rome Statute. As part of this mandate, Cyprus actively participates in meetings and informal consultations with relevant stakeholders, including representatives of states, court officials, parliamentarians, international organizations, and NGOs. In fact, we consider the principles of ICC as an integral part in promoting sustainable peace, stability, and security. More than that, the international legal framework created by the Rome Statute emphasizes the vital importance of ending impunity for the perpetrators of the worst crimes. It was therefore only natural that the Cyprus government fully supports the initiative of Costas Mavrides and the Cypriots Against Turkish War Crimes to formally request that the ICC initiates an investigation into the settlement activities of Turkey in the occupied part. Activities which, according to the complainants, constitute a war crime of changing the demographic of Cyprus. The evidence to that is there, and it is convincing. It is a well-established fact that the demographic character of the island has been continuously altered since 1974 as a result of the deliberate policy of Turkey to transfer thousands of its citizens to Cyprus. Actually, the problem of settlers is one of the most difficult and politically sensitive chapters in the negotiations for the solution of the Cyprus problem. The Turkish position is that all those who acquire the so-called nationality of the Turkish Republic of Northern Cyprus have to become citizens of the federal Cyprus coming into being. Despite our clear disagreement on this, we work in a constructive manner to find arrangements that are both legally and politically compatible with international, European and humanitarian law. It should be recalled that according to the Fourth Geneva Convention, an occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies. In 1992, the Council of Europe, through the so-called Kuko report on the demographic structure of Cyprus, concluded that the demographic composition of the island was being radically altered as a result of the settlement of thousands of foreigners brought in from Turkey. The Kuko report led to the adoption of a recommendation by the Parliamentary Assembly of the Council of Europe, which inter alia concluded that since natural rates of increase of population are compatible in both parts of the island, the population growth in the north must have been due to a substantial influx of migrants. The aim has been to encourage the permanent settlement in the island. Migrants are granted housing, land or properties on special terms. However, the most important has been to allow them to acquire Cypriot nationality and hence political rights. the presence and naturalization of the Turkish migrants who once established on the island become settlers constitute an additional obstacle to a peaceful negotiated solution to the Cypriot conflict. In light of the above, the Assembly recommends that the Committee of Ministers instruct the European Population Committee to conduct a census of the island's population. In 2003, following the submission of the Laxko report, with the telling title Colonization by Turkish Settlers of the Occupied Part of Cyprus, the Council of Europe adopted another recommendation which inter alia states that despite the lack of consensus on the exact figures, all parties concerned admit that Turkish nationals have been systematically arriving in the northern part of the island. According to the said report, their number amounted at that time to 115,000. The fact that there has been no internationally observed census to account for these arrivals shows an implicit understanding of the crime at hand. It is true that the International Criminal Court does not have jurisdiction over activities that occurred prior to the entry into force of the Rome Statute in 2002. However, the deliberate illegal settlement of Turkish nationals has continued unabated since. Our estimates suggest that since then, more than 120,000 nationals have illegally settled in Cyprus. Characteristic manifestations of Turkish pro-settlement policy are also to be found in other areas, such as the creation of job opportunities that are solely for the benefit of Turkish nationals and the employment and social security rights of Turkish citizens in the occupied area, aiming at the regularization of the status of the many Turkish citizens who have unlawfully arrived. The impact of Turkish settlement activities, together with the presence of 40,000 occupying troops, has further cemented Ankara's grip on Cyprus. Turkey's continuous effort to control the occupied part is also reflected in the illegal project for the supply of water from Turkey to Cyprus, inaugurated only 2 days ago in the presence of Erdogan himself. Let me conclude on a more promising tone. In our endeavour for lasting peace in Cyprus, issues of justice assume increased importance through the Rome Statute of the International Criminal Court, which has set new parameters for conflict resolution. We fully recognise the political and practical challenges of prosecuting perpetrators for complex crimes. But we should be determined to put an end to impunity. One thing is clear. Without justice, there can be no inclusive and lasting peace. There can be no closure. Only then, justice and peace can be truly mutually reinforcing. And while the International Criminal Court is focused on serving justice, by doing so, it facilitates the quest for peace. Thank you very much.
Very well. Very well, Ambassador Corneliu. Just to summarize a few points, a shameful anachronism against the rule of law, that is occupation and settlement of Cyprus by Turkey, change of demographics and the character of the island, the Guko report, and finally, incentives for Turkish nationals to transfer to Cyprus, and finally, if there is no justice, basically there is no lasting peace. Now, I'm going to turn to Professor Eugene Kondorovich, who came all the way from the States. And it is indeed, I'm very happy that we have him here today with us. Just a few words about Professor Kondorovich. He is currently the head of the International Law Department of Northwestern University in Chicago. He is an academic for decades, even though he is quite young. He is an author, a researcher, an advisor to governments, bringing testimony and expertise to the U.S. Congress, and perhaps one of the leading experts on international criminal court matters. Professor Kondorovich, you have the floor.
The button?
Yes.
Thank you. Thank you. It's a pleasure to be here. I'm an international lawyer and an international law scholar, and the issue before us is one of both great importance, great interest, and great novelty. The question of Turkish settlements and the migration of mainland Turks into northern Cyprus is one that has received relatively little attention by the international community and by scholars. You have here a picture of what would be called settlement construction in northern Cyprus. These pictures are not ones that you will see in the newspaper every day. I sent a research assistant to northern Cyprus to document some of this. And as you can see, it is a multinational issue. I particularly like this photograph because you can see in the background these settlements and new settlement construction that will change the demographics of northern Cyprus is being marketed to people from multiple countries. I think you see the British, the Swedish maybe flag in the background, Norwegian maybe. As you can see, this is a multinational issue. Now, it's also an issue clearly for the ICC. Cyprus is an original member of the ICC. It joined from the very beginning. So there is no question of territorial jurisdiction. Many of the preliminary jurisdictional issues that can be difficult elsewhere are quite clear here. This occurs in a territory which has been part of the ICC since the beginning. Nor is temporal jurisdiction an issue. While many people believe that the movement of Turkish nationals to the island is one that followed immediately upon the invasion and was largely concluded soon after, indeed that process has continued to this very day, not just in the 70s and 80s, though a lot of it happened then. Indeed, a Turkish demographic study in a Turkish language journal claimed that population has grown rapidly in recent years. Cable by a U.S. ambassador in 2005, which is available to us through WikiLeaks, claimed that in recent years the influx of settlers had reached new heights, with maybe 10,000-15,000 moving to the island in any particular year, which is quite significant considering that the population of the northern section is just under 200,000, so this is a significant annual change in the population of the occupied territory. Rome Statute Article 8.2b8 makes it a crime for an occupying power to directly or indirectly transfer its population, its civilian population, into the occupied territory. Now, this provision, one must say as a lawyer, lawyers generally speak based on precedents and on what's happened in the past. This provision is one that has never been construed judicially before. This is not a provision that anyone has ever been prosecuted for in any national or international court, and it must be said that a lot remains unclear about the precise scope of its applicability, about what constitutes deportation, about what constitutes transfer, about what constitutes directly, and what constitutes indirectly. But this is exactly what the ICC might shed some light on. Indeed, the Cypriot situation would be an appropriate case in which to elucidate these principles. First of all, it involves the occupation of the territory of the European Union. That's a bit of a shocking thing to say, and every time I say it, I'm shocked, but it is the European Union itself that is under belligerent occupation, and the European Union as a normative power, as an agency that prides itself on being a leader in international law, one would think would see this as a priority to sort out the rules, not just in its own backyard, but really in its own house. In particular, the effects of this population transfer have been amongst the most significant of any similar phenomenon in modern times. In particular, the population of the migrants into northern Cyprus may now be half the population of the territory, rivaling the situation in Western Sahara for the greatest impact demographically. Now, statistics about the precise numbers of migrants are controversial, and indeed the lack of clarity and the lack of international fact-finding on this issue is one of the problems that investigations, international criminal investigations, could solve. This is a serious issue. It has been a major sticking point in negotiations between Cyprus and the North. And we know that there have been mechanisms to encourage some of the migrants to come and major Turkish-funded infrastructure projects. So in terms of temporal jurisdiction and in terms of geographic jurisdiction, the situation seems like a situation for the ICC. And indeed, the Republic of Cyprus has encouraged the ICC to be involved. In a document submitted by the Cypriot Foreign Ministry to the British Parliament's Foreign Affairs Council about 5 years ago, the Republic of Cyprus said that Turkey is in violation of the ICC statute and has illegally implanted these settlers in Cyprus. Last year, in responding to the complaint brought by Mr. Mavrides and other Cypriot refugees, the Foreign Ministry of Cyprus said that it was placed itself at the court's disposal to provide documentation on the colonization of the occupied area of Cyprus. And indeed, just a few minutes ago, the ambassador said that Cyprus fully supports this initiative. And indeed, this has been going on throughout the court's jurisdiction. So it's a little bit surprising, to me at least, the response by international organizations and NGOs. So this slide documents the response of Amnesty International, Human Rights Watch, the European Parliament, and other major normative players to ICC jurisdiction over these crimes. In short, there has been a deafening and surprising silence. There was a statement by Council of Europe which did not relate to the ICC in particular because of the timing. And international NGOs that claim to promote the international rule of law and end to impunity have been amazingly silent about the ICC's role in this situation. Now, to be sure, any ICC investigation would, as a technical matter, raise many questions and face various legal issues. And precisely because Article 8.2b8 has never been construed by a court, there's a lot that remains unclear and a lot that remains undefined. One can understand why the ICC is not eager to jump into such uncharted waters. There are indeed difficult questions. For example, one of the major efforts of the northern Cypriot Turkish regime has been to establish universities. There's about a dozen universities established in the occupied territory. Education is a major industry, and many thousands, tens of thousands of students, Turkish and otherwise, live and study at these universities. Do these students count as part of the settler population? European parliamentary documents have been unclear on this question. What about the situation of what Turkey calls temporary workers? What about, a particularly interesting question for the European Parliament, what about third country settlers? The northern Cypriot regime has made an effort, successful effort, to encourage people to move to the area from third countries, in particular Britain, for example, and has become a vacation and retirement destination. What is the status of these people? The language of Article 8.2b8 speaks of the transfer of the population of the occupying power. However, as this provision has been explained or understood in other contexts, it might also refer to nationals of third parties. That's an interesting and open question. In some contexts, various bodies have questioned whether the children born to Turkish settlers, baby settlers as I described them, would be counted as part of the deportation or transfer. And this is a quote from a document by the UK Parliament Foreign Affairs Committee, which a few years ago sent a fact-finding mission. Many of these so-called settlers were born on the island and know no other homeland. This is an open question. Does one count them or does one not? The answer is quite important, as there are quite a lot of them. In other contexts, the international community has clearly regarded baby settlers to be part of deportation or transfer. So the openness of this question is unclear. Now, why has the ICC done nothing in this area? So here I'm purely speculating, because they haven't said anything on the subject, and I believe Mr. Mavrides invited a representative from the prosecutor's office to attend this meeting, but they begged off, saying they can't comment on possible situations, though I believe they have commented on possible situations in other possible situations. So one major development in the ICC's docket occurred just a few weeks ago. Their first out-of-Africa case, the situation involving Georgia. And perhaps we can learn something from the ICC's treatment of this situation. Georgia has also a long-standing member of the ICC, was involved in a war with Russia in 2008. And since then, and also before then, Russia has occupied various regions of the Republic of Georgia, in particular South Ossetia and Abkhazia. A few weeks ago, the Office of the Prosecutor announced that it was going to request a full investigation of the situation in Georgia. However, it limited temporarily the investigation to the time of actual hostilities, of actual armed conflict between Russia and Georgia, and which ended in 2008, thus leaving out basically the next 6-7 years up to now of Russian settlement activity, particularly in Abkhazia, where Russia has encouraged migrants to come into the territory for the purpose of changing the demographic balance of this territory. So the ICC decided to leave that out, and they did not explain in their request for a full investigation to the pretrial chamber why they saw fit to not include Russian settlements in occupied Georgian territory within the scope of their investigation. But one might imagine that perhaps the ICC thinks it should be more interested in the, let's say, acute phase of a conflict rather than in the potentially long tail end of occupation-related offenses. And this would also be relevant to potential situations in Palestine, potential situations in Ukraine, which has now also accepted by declaration the jurisdiction of the ICC. One might imagine that the prosecutor is mostly interested in the actual hostilities in the Ukraine, not in what could be decades of Russian migration into Crimea and eastern Ukraine. That's a possible explanation, and it would fit potentially with the ICC's treatment of other situations. But it's an explanation which the prosecutor has not made. And indeed, one point of urging a preliminary investigation, a preliminary examination, would be so that the prosecutor can tell us exactly why this significant demographic change does not warrant the opening of a situation. These are things that the prosecutor could tell us, that perhaps they aren't interested in this kind of thing. Perhaps they're only interested in hostilities that involve loss of life. But that's not for me to say. That should be for the prosecutor to say in a consistent manner. And indeed, a preliminary investigation would be a useful way of clarifying these issues. Not having even a preliminary examination to begin to look into a possible inquiry into these potential violations by Turkey effectively reads deportation or transfer out of the Rome Statute. That is to say, this is part of Europe. It is an area where this activity has been going on continuously since Cyprus became a part of the Rome Statute. And a failure of the ICC to act would suggest that this is fundamentally not something where they are interested in ending impunity for. Now, that may be the prosecutor's position, but it would certainly be better to hear it from the prosecutor and have the prosecutor have to account to the Republic of Cyprus and other interested parties for taking that position. Okay, that is the extent of my comments. Thank you.
Thank you, Professor Gondorovic. Just a few points. If I truly want to summarize what he has said, maybe I have to repeat the whole speech. So just to mention that relatively little attention to Cyprus, even though it is part of the European Union. And that is very striking. The transferring of Turkish settlers maybe continue even up to today at very high levels. And no one has ever been persecuted for such crimes, and Cyprus can be the first precedent or the first case, given that it is quite appropriate, given the magnitude of the crimes committed for decades and for the demographics of Cyprus. Okay, now we are moving to our third guest. Our third guest is Professor William Shabazz. He has close relations with Cyprus, actually, and just a few words about his professional background. He's a professor currently of international law at Middlesex University in London. He's also a professor of international human law and human rights at Leiden University. He holds several academic associations with many universities, just to mention a few. The Paris School of International Affairs, the Chinese Academy of Social Sciences in Beijing, the Kellogg College of the University of Oxford, the Quebec University, and many others. He also served as an advisor to governments and also served as an advisor and expert to the UN. Professor Shabazz, you have the floor.
Thank you very much, Deputy Mavrides. I said to my colleague, Professor Kantorovich, before we were speaking that I would let him go first because I would probably agree with everything he said, and then I could be lazy at this point and just say thank you very much. I'm not going to decline to speak, but I do, I think, essentially agree with his understanding and approach to the question. So what I propose to do now is to talk a little bit about the issues that he raised and then to talk about another dimension of the problem, which is how the case goes before the court, how it would advance, and how the court would take decisions about how to deal with the Cyprus issue. The starting point, of course, at the International Criminal Court is this question of jurisdiction. We have to establish that the court can actually prosecute the crime or the crimes. That involves identifying the crimes, and not every possible crime is subject to the jurisdiction of the court. People are often surprised to learn that the crime of aggression, the actual invasion of a country, an attack on a sovereign state, is not yet subject to prosecution by the International Criminal Court. That's something that's changing. There are amendments to the statute of the International Criminal Court that we expect will come into force in 2017. And so in the future, it will be possible then to deal with crimes of invasion, crimes of aggression, but not now. There is a range of other possible crimes for which prosecution can be undertaken at the International Criminal Court. But here, the major impediment is the question of the time, the temporal jurisdiction, because the International Criminal Court can only address crimes that took place subsequent to the 1st of July 2002. And the crimes that may have been committed in Cyprus prior to the 1st of July 2002 simply cannot be addressed by the International Criminal Court. There may be other courts where those crimes can be taken up, and as I'm sure many of you know, many of the violations, not defined as crimes, but defined as violations of international law, have already been addressed in a range of judgments by the European Court of Human Rights, including the Grand Chamber, and there have been, amongst other things, huge awards that have been ordered by the Grand Chamber of the European Court of Human Rights. But we have to, if the Cyprus issue is to come before the European Court, the International Criminal Court, identify crimes that have been committed since the 1st of July 2002. Now, you've already heard that there is significant evidence that the crime of transferring directly or indirectly a country's population, the occupying power's population, into an occupied territory has been committed since the 1st of July 2002. And so this provides a basis for prosecution by the court. My colleague is quite right to say that this hasn't been interpreted. We can take a small amount of legal writing that was done in the past on the subject. There are a lot of smart lawyers these days, not so much in Cyprus as in the neighboring country, in Israel, on both sides, who are studying this intensely. And so I would expect that in the months and years to come, we're going to see doctoral theses and books and everything exploring this possibility and exploring the interpretation of the provision. But ultimately, like all legal provisions, it comes down to 3 or 5 judges sitting in a chamber at the International Criminal Court who are going to flesh out the interpretation of this provision. And the issues, the types of issues that will arise have already been explored. The provision speaks about the occupying power. So this is a crime that has to be committed by the state. It's unusual in that respect. It's very rare in the Rome Statute of the International Criminal Court to specify that a crime has to be committed by a state. But that seems to be the implication of this provision. So it's an unusual provision in that respect. And it also speaks about its own people have to be moved in. It uses these words directly and indirectly. And those words were added in the Rome Statute. They don't appear in the provision in the Geneva Convention, in the Fourth Geneva Convention. But they were added, I think, not with an intent to amend the Geneva Convention, but simply to assist in interpreting it properly, so that the transfer of the population can be by indirect means as well as by direct means. And that's obviously something of great relevance in this case. So I think that is what we're looking at. That's the crime. We don't know the limits of it. We don't know the interpretation of it. But neither does the prosecutor, and neither does anybody else. And so we can look upon it with trepidation, but we can also look upon it as a bit of a blank sheet waiting for legal interpretation to be written on it. And I think what's important, and where the Cypriot cause stands in a strong position in terms of the interpretation, is that it's clear that that provision exists in the Rome Statute as it exists in the Fourth Geneva Convention and as it exists in the first protocol to the additional protocol to the Geneva Conventions of 1977. It exists to deal precisely with the situation that has happened in the north of Cyprus. That is the transformation demographically, the transformation of the demographics, of the culture, of the economy by an occupying power whose occupation is always supposed to be temporary, even if it's justified under the circumstances. And Mr. Mavrides spoke at the outset of the unlawful occupation, but even if it's a lawful occupation, the crime can still be committed, in fact, because the occupier is always supposed to leave, and supposed to leave the country in the condition, as much as is possible, in which the occupier found it. And so I think there can be a high level of confidence that actually the provision will be interpreted in a way that will be open and favorable to the events in Cyprus. I say since 1974, but essentially it has to be also since 2002. And I have no doubt, by the way, that the International Criminal Court, in interpreting the provision, in interpreting the intent behind the provision, the damage caused by the crime, will bear in mind the events prior to 2002, even if it cannot prosecute them, in the same way that the Nuremberg Tribunal in 1946 looked at the events that took place in Nazi Germany from 1933 to 1939 even though it felt that it could not convict Nazis for those crimes. So I think that that material and the events that took place and the policies of Turkey from 1974 to 2002 will not be irrelevant in the judicial debate before the court. Now, what is going to happen in practice? The International Criminal Court, at the first stage, is entirely in the hands, really, of the prosecutor of the court. I used to lecture on this. I've been lecturing on the International Criminal Court since it all started, 15 years, and studying the preparation of the court even before that. I've written books and tried to analyze it and followed it in great detail. If you had asked me 10 years ago, I would say there are 3 ways that a case can come before the court. It can come as a result of the Security Council. It can come as a result of a state that's a member of the court, asking the court to prosecute a situation. And it can come as a result of the prosecutor of the International Criminal Court acting on her own initiative. Today I say it a little differently because it's become clear to me that ultimately everything rests with the prosecutor. In this situation, we need not concern ourselves with the United Nations Security Council because the United Nations Security Council really only becomes important when a country hasn't yet joined the court. And that's how Sudan and Libya have come before the International Criminal Court. There have been efforts to get Syria before the International Criminal Court on that basis as well, but they have not been successful. But that need not concern us. The other 2 ways of unleashing the prosecution, one is to have a state make a formal, what we call a referral to the court, and the other is simply for the prosecutor to decide to proceed. But even if a state makes a referral, and Cyprus would be free to do this, Cyprus as a state party, as a member of the court, could certainly make a formal request to the International Criminal Court to begin a prosecution. This wouldn't really change very much, I don't think, because ultimately the prosecutor remains free to decide whether or not to go ahead. In some cases where states have referred situations, the prosecutor has decided to proceed. But in one other situation, the prosecutor said, no, thank you. I don't want to do that. It doesn't suit my priorities. So this is a matter largely up to the discretion of the prosecutor. And in this case, because Cyprus is a member of the court and has been since the court began on the 1st of July 2002, the prosecutor has had jurisdiction, has had the authority to proceed with a case since that time. And so it's ultimately all in the hands of the prosecutor. Now, I think we should all be confident that we have a very professional, neutral in the best sense of the word, objective, impartial prosecutor. I would not have said this 7 or 8 years ago when the first prosecutor was in office, but I feel comfortable saying that today. And the staff of the Office of the Prosecutor is a highly professional group of lawyers who are committed to fulfilling their mandate and to carrying out their responsibilities with objectivity, impartiality, independence, and neutrality. And what that means is that if they have a strong submission before them, they will deal with it in a serious and principled way. I myself was involved last year, a year and a half ago, in making a submission to the prosecutor of the International Criminal Court dealing with the conduct of British forces in Iraq. And together with 2 groups of professional lawyers, non-governmental organizations, we prepared a very detailed submission documenting events, documenting alleged crimes, presented it to the Office of the Prosecutor. Subsequently, several months later, we were invited to come and meet with the staff of the prosecutor, and about a week later, the prosecutor announced that she was going to go ahead. And that surprised us, and it impressed us, but it makes me extremely confident that if material is submitted in a professional manner to the prosecutor, that she will take it through the proper stages. Now, what are those stages? Right now, the Cyprus file, you could say, is at the pre-preliminary examination stage. This is in a gray ether in the statute of the International Criminal Court. Because right now, what the prosecutor has to determine is whether to begin the preliminary examination. The preliminary examination is the first step in the Rome Statute. It's governed by Article 15 of the Rome Statute, and it's the first step where the prosecutor starts to examine a case officially. And she can do this on her own initiative without any authorization by judges. If you look on the website of the International Criminal Court, you will see, you'll see two columns describing where the International Criminal Court is active. The left-hand column are what we call the situation countries. These are the ones where the prosecutor is actually identifying suspects and proceeding with trials. And until Georgia migrated to that column a week or two ago, they were all African countries. This was a problem. It was a source of much criticism of the court, and that started to change a few weeks ago. On the right-hand side are another 8 situation countries that are subject to preliminary examination. And this is where the prosecutor is looking at the situation and deciding whether or not to ask judges for the authorization to proceed. And those countries are mainly, I think with one exception, outside of Africa. And when one looks at them, one sees that there's a certain amount of, I don't want to say ambiguity, but you have to read the list closely to see what they're talking about. For example, Iraq is on the list. It should have an asterisk saying, actually, we're not looking at the Iraqis, we're looking at the British, because that's what that investigation is about. Afghanistan is on the list. And there, one can look at earlier documents by the prosecutor that indicate that amongst other subjects, the prosecutor is looking at the conduct of the United States of America in Afghanistan. I think there are probably some senators and congressmen in Washington who haven't yet realized this, but actually, formally, the prosecutor has already stated that she's investigating the United States with regard to Afghanistan. And Palestine is on the list. And of course, the prosecutor may be investigating crimes committed by the Palestinian rulers, but she may also be looking at crimes committed by the other side in that conflict. And finally, Ukraine and Georgia. Georgia was on that list, and that meant Russia. This is quite a stunning development in international law. Never before have we had permanent members of the Security Council on the list of the prosecutor. Powerful countries. I pick on the permanent members of the Security Council because they're an easy target, but there are other powerful countries that the prosecutor's been looking at as well. And so this is an exciting development, and the challenge right now for the Cypriot application is to get onto that list. And there are countries who are terrified about being put on the list. Turkey must be one of them, but there are others. And you can read the NGO materials to see who's making the complaints. There's intense lobbying that goes on in The Hague with the people at the Office of the Prosecutor, by ambassadors, by NGOs, either to get people onto that list or to get them off, or to make sure they never get on the list. And I guess that's a difficult, aggressive, competitive game that those who want to see this case advance are going to have to play in the Hague with the Office of the Prosecutor in that context. Once the prosecutor decides that she wants to go ahead with the Cyprus case, if she decides this, in other words, she does the case graduates to the preliminary examination, and then after examining it, the prosecutor concludes that she can make charges, that she has a case, then the prosecutor has to go before 3 judges of the court and ask for their authorization. And that's happened in 2 situations to date. To be as candid as I can about that process, the judges are not very demanding. If the prosecutor actually makes out a reasonable case, the judges virtually rubber stamp that stage. And then the prosecutor goes about identifying the individuals who are to be prosecuted. So this is how the case will move forward. Let me just, because I think I've probably gone on longer than I should, let me just make one other comment about this. This is, as you can see, there's a legal framework. There's a legal framework for getting the case to move forward, for getting the situation in the north of Cyprus to move forward at the court. What it's harder to put our finger on is what the policy considerations are. Right now, the prosecutor will say that the policy considerations are essentially technical in nature. In other words, if all of the boxes get ticked to move the situation forward, then she will proceed. That may be the case, but there has to be a dose of judgment and of discretion in doing it, and it's going to become more intense in future years simply because the prosecutor now has too much work. There are too many cases and situations before the prosecutor, and at some point the prosecutor is going to have to realize you cannot, with her staff, with the number of judges, with the size of the court, move forward with 19, 20, 25 countries, and as I mentioned, underneath the names of some of those countries, Iraq, Afghanistan, Palestine, you have other countries. And so at some point, it seems to me, as someone who follows the court, the prosecutor will have to say, I can't do all of these things. I'm going to have to use my discretion and pick and choose. The interesting question is how much the peace factor contributes to that discretion. How much does the prosecutor look at whether or not the prosecution will contribute to promoting peace or perhaps undermining negotiations for peace? We have historic examples of both of these. Recently in Colombia, a peace process, it hasn't ended, but there have been very intense negotiations and a lot of progress was made, and there the stumbling block, the defining issue, was the role that the International Criminal Court might play in the peace process. And that's something that will have to be considered, no doubt, in Nicosia. This is being discussed and considered in the Foreign Ministry as to how hard a prosecution at the International Criminal Court, how much that would contribute to peace or perhaps provide an obstacle. Last year, when Palestine was talking about joining the International Criminal Court and bringing the situation in Palestine, not just the occupation, but other issues related to the conflicts before the court, European countries, some of them the big supporters of the International Criminal Court, the leaders in the European Union, were saying, don't do this. Don't go ahead, because the International Criminal Court will make the peace process more complicated. And that's an issue. I leave it. I don't want to even venture onto that territory and debate whether or not that's the case. But it's an issue that has to be addressed and has to be considered. I think that when you look at the situation, and I'll conclude just with this remark, when you look at the situation of an occupation for 41 years, where the situation is stagnant, where it doesn't advance, where the temporary occupation, the occupation that's supposed to come to an end, doesn't come to an end, we have to try these other mechanisms, these unpredictable mechanisms, and perhaps they will change the game. And so I think that's the opportunity that the International Criminal Court presents for the Cyprus question, and it's something to which we have to give our full attention. Thank you very much.
Thank you, Professor William Shabazz. Before I compensate Professor Eugene Kondorovich for 3-4 minutes, please allow me to make a very short summary of what you have said, a couple of points, and concentrating on the role of the prosecutor, which seems to be very crucial for our case as well. But also I noticed that you have mentioned the Cyprus case has very strong provisions that support the whole criminal case about Cyprus and fits well the actions of Turkey in Cyprus. Now, Eugene, Professor Kondorovich, you have the floor, but before doing that, please allow me to welcome two distinguished colleagues of mine, Mr. Kefalogiannis. Where is Mr. Kefalogiannis? Here it is. And Dimitris Papadakis. And, of course, Father Porphyrios, who is not a colleague of mine yet. Okay, Eugene, you have about 3-4 minutes.
Thank you.
Excuse me, Eugene. And we have with us also Ms. Sofia Sakorafa, a member of the European Parliament from Greece. Yes, Eugene.
Thank you. As Professor Schabas said at the beginning of his comments, while he did not have much to disagree with, he would still speak, and in the best professorial tradition, I will not lose an opportunity to speak either, even though there's no sharp disagreement here. It's true that the ICC has limited resources. It's true that the ICC can't solve all the problems in the world. And it may be the position of the ICC that faced with conflicts that are killing tens of millions of people around the world, it needs to pick its battles. And implicit, I think, in its approach to the situation in Georgia is that when it picks its battles, it's going to focus on battles, so to speak, not on ongoing occupation-related issues that do not necessarily involve the loss of life. And that may well be the outcome of the situation in Palestine, where apparently more emphasis is placed on the Gaza war, and that is seen as the crux of the issue. However, what those situations have in common, that our present context does not, is that they at least had a preliminary examination in which the prosecutor could articulate these issues. And if the prosecutor chooses to then say, I'm picking a narrow temporal focus, just to take the given case of Georgia, I'm taking the war in 2008, not everything that went on afterwards. So if you were to apply that precedent to Cyprus, you'd say, well, unfortunately, the war was outside of temporal jurisdiction, and we are not the place for that. That is a position which one can understand that the ICC could take, unless European Parliament and others give them more money. But it's a position which they need to themselves take and explain what their priorities are, because otherwise it seems mysterious, and when not explained, it seems arbitrary and weakens the credibility of the ICC. So, for example, Cyprus, again, joined the ICC in 2002. And I looked back at the newspaper headlines and tried to understand what was the mood at the time. Nobody was suggesting, and maybe it's because they didn't take this as a serious part of the ICC's jurisdiction, nobody was saying, well, Turkish settlements in northern Cyprus are in trouble now because Cyprus just joined the ICC. That's really going to change things. And indeed, nobody seems to have been talking about that. And the ICC is partially responsible for that. Apparently, this was not seen as a key issue for the ICC to address, and I would like to hear from them why. That is something which they need to explain. That's something which the international community needs to explain. Why Cyprus' joining the ICC. It was not thought by anyone to have any immediate, not as a legal matter, but as a de facto political matter, for the Turkish presence in the northern part of the island. And the ICC has chosen to be quite obscure on this. Similarly, when now that Ukraine has joined the ICC, issued a declaration under Article 12.3, nobody is saying, well, that's the end of the bridge Russia is building to Crimea, which is going to make it easier for people to come in. That's the end of the bridge. They're going to have to stop building that bridge. That does not seem to be a focus, and most of the focus is about ICC potential jurisdiction over ongoing armed conflict in eastern Ukraine and the Donetsk-Lugansk issue. But again, if the ICC wants this to be taken seriously as part of its statute, as a crime within its jurisdiction, it needs to explain exactly how it sees it and why sometimes it appears to not see it.
Thank you, Professor Kondorovic. I'd like also to apologize for not noticing the presence of another colleague of mine, Miltos Kirkos, an MEP from Greece as well. Okay, now I'd like to open up the floor with questions or comments about the subject matter? Where would you like to start? Anyone?
Start with the MEPs, probably.
Yes, I'd rather to start with the MEPs first if they want to say anything, or if they feel to intervene at any point in time, it's okay with us. Okay, who would like to be first online? Mr. Prodromou.
Professor Eugene Kondorovich and Mr. William Shabbas, as international leading experts in such issues, would you please tell us if Turkey respects the decisions of the ICC or the International Court of Hague? And if not, is there any way that the international community or the European community could take so that Turkey is forced to implement the decisions and respect the international law?
Maybe we take one more question and then you have a chance to answer it and respond. One more question? Yes, Mr. Iwanas.
I would like to ask the two professors, what's the restitution, what's the remedy for these crimes? Is there something we can say about that, if the ICC takes up the fight?
So in reference to the first question about Turkey's compliance with ICC directives, I think their compliance has been perfect because the ICC has not issued any rulings or directives addressed at Turkey. And Turkey is also not a member state, so it's not clear the extent to which it would need to go along with preliminary directives. So you might be referring to judgments of the European Court of Human Rights, which have decided cases involving Turkish action. And I'm afraid I don't know the status of Turkish compliance with those directives. I haven't checked up on whether they have implemented or complied with the several decisions of the European Court of Human Rights. In terms of remedies that can be imposed by the International Criminal Court, so the European Court of Human Rights awards financial and moral damages. The ICC is a criminal court. Its principal remedy is to put people in jail. So it would not issue a directive, for example, requiring the removal of Turks from Cyprus. That would be well beyond its competence. It would be dealing with the actions of particular people and would potentially be issuing jail sentences. They can also provide some restitution to victims, but it is not clear how victims would be defined in this context if we're not talking about possession of particular properties, but migration in general. So the principle, what the ICC does, and they haven't done this much at all, but what it in theory does is put people in jail.
Professor Shabazz?
I can't add anything to that. That's
Okay, very well. Let's go one more round of questions and comments. Let's go one more round of questions or comments. Anyone? You may pose the question in Greek or in English. It makes no difference. We have live translation. Yes, or some of our Turkish friends who are present may pose a question as well. Yes, Mr. Rakos.
Good evening, Riakos Seraphim from Cyprus. Could we derive any kind of lessons from the way the Baltic states treated the colonialism of Russia and when they were brought into Europe? Thank you.
It's an interesting issue. The Baltic states were, some say occupied, some say incorporated into the Soviet Union. In fact, while several countries did continue to recognize the ongoing legal personality of the Baltic states, the vast majority of countries in the world saw them as an integral part of the Soviet Union, whether fairly incorporated or unfairly incorporated. The issue of Russians living in the Baltic republics who moved there after Soviet annexation of those republics was a sore point between the Baltic states and the European Union as the Baltic states became members of the Union. Generally, the Baltic states wanted to impose more severe measures against these people, strip them of citizenship, take measures that would require them to leave, and the European Union took a very dim view of that, and generally saw it as a matter of human rights that the Baltic states not be able to implement those measures. As a result, those Baltic states do still have very large Russian populations.
I'd just say that one of the difficulties, one of the challenges in dealing with these types of issues, including, of course, the situation in Cyprus, is a reluctance of international law to look too far to the past. There are obstacles at every step of the way. Earlier this year, in a case before the International Court of Justice, the World Court in The Hague, the judges said that the Genocide Convention, which was adopted in 1948 and which said that genocide had been committed at all times in human history, that it could not apply to anything that happened before 1948. 2 years ago, the European Court of Human Rights refused to look at a case that dealt with the contemporary consequences of the massacre by the Soviet Union at Katyn in 1940. Last week, there was a decision of the European Court of Human Rights dealing with denial of the Armenian genocide. And there, in that judgment, the judges of the European Court say, don't look too closely at the past. This has to get more dimmer and dimmer as time goes by. And so this is one of the problems that we're confronting, and it's a problem, of course, in the Baltic states as well. That's why that rule, which seems so offensive in the Rome Statute, of the non-retroactive application, that it can only apply to events subsequent to the 1st of July 2002, even if transferring settlers into an occupied territory was condemned in the 1949 Geneva Convention. And furthermore, it was declared to be a grave breach of the Geneva Conventions in the additional protocol, which was adopted in 1977. But it would have been impossible to get states to agree to the Rome Statute in 1998 if it was going to apply to the past, because too many of them have ugly events, skeletons in their closet. And so we can welcome the idea that the international community said in the Rome Statute, henceforth, these crimes are going to be punishable. And that's a good development. And what we welcome as well is that it will hopefully deter further violations. But that's not a lot of consolation for refugees, for people who were victims of these crimes in the past. I repeat, as I said in my remarks, and as my colleague said as well, the case has to be built around violations subsequent to the 1st of July 2002. I think right now this isn't a matter for the prosecutor. As I say, I think this looms on the horizon. But I don't believe that in the way the prosecutor is looking at situations that this is something where she'll say, 10,000 people were killed in this country. That's more serious than settlement. What my hope is that the prosecutor understands that the survival and the future of the court, aside from the interests of particular groups of victims and societies in the cases that go before the court, but that the prosecutor will look at the fact that until very recently, her work has been focused entirely on African countries. These weren't easy cases in the sense that they were technically easy to prosecute, but they were soft targets in the sense that they weren't powerful countries that were going to get angry at you, like Russia and the UK and Turkey. And I think that the prosecutor has to realize that the future of the International Criminal Court and the credibility of it as an institution depends on it demonstrating that it's not afraid to deliver tough justice, fair but tough justice, to powerful countries as well as to weak countries. So that's the challenge that we have, and I think that's part of the argument to help to push forward this case of Cyprus, is to remind the prosecutor and the people around the court over and over again about how important it is that they show that they're able to deal with a big, powerful country and not just small, isolated countries in Africa.
Thank you, Professor. If Ambassador Corneliu wants to make any comment, he should feel free. By the way, Professor Shabazz, I have a question for you before I give the floor again to everyone. In your first speech, you made a comment about feeling very confident regarding the prosecutor especially, being principled and professional people. Expressing the view perhaps of many people that listen now or view us from the live link around the world, and thinking about Cyprus and having a very bad experience with Cyprus in getting justice so far, I'd like you to comment on whether you still believe that would be the case, your confidence with regards to Cyprus, and given that it is a small country against almighty Erdogan.
Well, I don't believe the prosecutor is troubled or intimidated by that. I think the prosecutor, as I said, is someone who is going to act in a fair and impartial manner. I don't think she'll take her decisions based on a number of factors about prosecution. Some of the factors also have to involve the amount of evidence she has. All prosecutors do this. Every prosecutor, even a prosecutor when a murder takes place, will decide not to prosecute because they don't have the witnesses, they can't get the evidence. So there are technical difficulties. She'll assess all of that. But is she going to say, I don't think I'll prosecute that because I'm afraid of Erdogan? I don't think so. I wouldn't be concerned about that. And I would say also, I mean, as I told you before we met, I first went to Cyprus in 1973. I was married in Cyprus in 1973. I was there before the invasion, and I've gone back there every year or two ever since. And so I followed this case very closely. Cyprus has actually had a fair amount of justice. The problem, one of the questioners asked, I'm talking mainly about the cases at the European Court of Human Rights, has now been with the enforcement. But the whole world knows, starting with Loizidou and then the interstate case by Cyprus against Turkey, that Cyprus has law, has right, has justice on its side. Collecting the money, I think Mrs. Loizidou is still waiting for her money, and that may take a little while longer. But this is, justice is more than a little money as well. And I think the value of the European Court's condemnation of Turkey in the Loizidou case and in the other cases is worth all the money that was awarded. Just as I want to say, the symbolic or the political value of it, because it makes it clear who's right and who's wrong. The problem with powerful countries is simply is getting at them. And the advantage of international justice is that sometimes you go after individuals, and so you may pick off the individuals along the way, and you frighten the individuals sometimes, and you change their behavior, and sometimes you catch them in unexpected circumstances. Think of General Pinochet getting arrested in London in 1998. He didn't expect that to happen, but all around the world, tyrants and dictators shuddered when that happened, thinking that might happen to me as well. So these are good lessons, and maybe we don't know how much they change the behavior of people, including the people in Turkey who might be tempted to repeat their acts.
Thank you. Ambassador Corneliu.
Thank you, Mr. Mavridis. Of course, it's very difficult to add anything substantial after these two excellent presentations by the two distinguished professors who are experts on this, in this area. But I was struck by a comment made by Professor Shabazz about lobbying of putting a country on the list or preventing the addition of a country. I was really surprised to hear that it happens also in the corridors of the International Criminal Court. It happens in the corridors of the European Union. We know that. You saw what happened last week, where an unwelcome visitor all of a sudden was offered not only red carpet treatment, but more than that. So it seems that also the International Criminal Court is not immune by the realpolitik. Unfortunately, this is an unfortunate thing, of course, because when it comes to the respect of law, political considerations should have no place. This is even more valid to a small country like Cyprus, and with a big neighbor, a very important neighbor. So international law and the respect of international law is our best protection, is our shield. And I would like, for this reason, also thank once again Mr. Mavridis for this excellent initiative, which enlightened also the government in this quest for justice. We have taken very good note of what you said. We are going to report back to our capital, and of course, once again, Mr. Mavridis, you have our full support in this effort. Thank you.
Of course, yes. You have the floor. Professor Sabas.
Thank you. I just want to clarify something so that there's no misunderstanding about my views on this. I mentioned that there is a lot of lobbying going on in The Hague with the prosecutor and with the people in her office. That's inevitable. There are ambassadors, your colleagues there in the Hague, and they're all doing their job on these issues. But I don't think we can conclude from that the prosecutor is vulnerable to political pressures. It's something that happens. It is a political environment, and so I think they politely meet with people. They hear their views. They ask them for information. But I don't think one should conclude that because the governments attempt to influence the conduct of the International Criminal Court through lobbying in The Hague, that they actually succeed in doing so. So I don't want to discourage you from doing it, but I wouldn't develop too much of a conspiracy theory either that certain ambassadors are handing out brown envelopes with money to the prosecutor to induce certain behaviors. Thank you.
Okay, let's open up the floor for once more. Yes, Mr. Kourouklidis. You have the floor.
If the ICC decides to investigate a case against Turkey, and in the meantime there is a political solution in Cyprus, how will the ICC proceed then?
Anyone? One more question? Yes. Mr. Athos. Hold on a second. Would you like to listen to English version? Yes, go ahead. Yeah. Συνεχίστε.
Δεν ξέρω αν αυτό που θα πω είναι σωστό. Άκουσα τον κύριο καθηγητή Σαπάς να λέει ότι έχει αποδοθεί δικαιοσύνη για το Κυπριακό. Θέλω να πάρω μια απάντηση για αυτόν ακριβώς το θέμα. Ευχαριστώ.
Professor Kondorovic and Professor Eugene, η Τουρκία έχει επικίσει και συνεχίζει να επικεί το κατεχόμενο μέρος της Κύπρου και έχει ουσιαστικά αλλάξει το δημογραφικό χαρακτήρα της Κύπρου στο κατεχόμενο μέρος. Πιστεύετε ότι επειδή σήμερα διεξάγονται συνομιλίες για τη λύση του κυπριακού προβλήματος, πρέπει να συγχωρεθεί η Τουρκία για το έγκλημα του επικισμού σήμερα?
The professors, you have the floor. You choose who wants to be first. You're very popular, Mr. Shabazz.
Well, the first question: what would happen if there is a settlement? What would that do to the ongoing investigation at the International Criminal Court? And in principle, the answer is nothing. That the investigation would proceed. And there's nothing that the peaceful settlement could do to block the investigation, because this is not between the governments. Turkey is not a member of the court. And Cyprus may want a prosecution to proceed, but if it changes its mind, it can't stop it. So I think the answer is that in principle nothing will happen, although perhaps the urgency will come out of the situation, and people may be inclined to think that the settlement also involves, in some sense, an acceptance, an agreement to move forward. And that will depend on what the settlement contains, and you know, that's some societies forgive and forget and move on, and others park difficult issues and return to them later, and some of them leave them there to be addressed. In Colombia, as I mentioned, they have a peace agreement, but it doesn't provide for amnesty. It provides for mechanisms for prosecution for the crimes. This is a special case because we're dealing with a crime, as I mentioned, that has to be linked to the government policy, and that also means that the individual who might be associated with it cannot be a second lieutenant in the armed forces. It has to be somebody at the top or pretty close to it, so that does complicate things. My comment about how Cyprus, and let me just be clear about how Cyprus had received some justice. I was referring to the judgments of the European Court of Human Rights, which, with some exceptions, have been victories for Cyprus. And those are important. And they tell the whole world about right and wrong and justice and injustice in that context. So that's what I was referring to. To say that everything has been solved, of course, we all know that that's not the situation now.
Thank you. Dr. Kondorovich, and by the way, also the decision by the European Court itself, since we are in the European Union, the case of Apostollidis against the Orams couple. Dr. Kondorovich? No. Okay. Any more questions? Yes. And before I give the floor, please allow me to ask Dr. Kondorovich a question. From a legal point of view, or from a practical point of view, are there any time limitations on this? Okay, you have the floor, sir.
Ναι, ήθελα να ρωτήσω τι είδους ποινές μπορούν να δοθούν από το Διεθνές Δικαστήριο σε...
Excuse me. Would you repeat the question again?
Ήθελα να ρωτήσω τι είδους ποινή μπορεί να δοθεί από το Διεθνές Δικαστήριο σε μια δυνατή χώρα όπως την Τουρκία. Τι είδους ποινή μπορεί να δοθεί, αν δικαστεί, αν καταδικαστεί.
Okay, we give the floor. As far as my understanding, this is a case not against Turkey. It's against Turkish officials, such as the chief commanders of the military occupying forces in Cyprus. But
yes, I would stress that this is not a case against Turkey. It would be a case against individuals. And I don't expect anything because this is a very far off. That is to say, as Professor Shabas outlined, first there is a preliminary examination, then there's an investigation, then there are indictments, and then there are cases. Just to give you an idea, the preliminary examination in Georgia lasted 8 years. So if expect means to anticipate, we are very far from expecting anything here. And there's really no basis to know how the ICC would deal either with these particular kinds of charges, with which it has never dealt before, or with officials of a powerful non-member state with which it has never dealt before. I would note that based on their recent request to open an investigation into the situation in Georgia, which was a conflict involving Russia and Georgia, the referral did refer a great deal to South Ossetian forces, which are Russian proxy occupation forces, suggesting a desire not to want to go very high up the food chain in that conflict on the Russian side. But again, it's important to know law as a science is based on prediction from precedent. There is no basis for any kind of prediction here.
Side. Yes. Mr. Erodogrid.
Στην Κύπρο υπάρχουν χιλιάδες Ευρωπαίοι πολίτες κλεπταποδόχοι. Έχουν αγοράσει στα κατεχόμενα σπίτια εξοχικά και κατοικούν μόνιμα στην Κύπρο. Επίσης επισκέπτονται την Κύπρο χιλιάδες Ευρωπαίοι πολίτες ως τουρίστες. Τι έχετε να πείτε γι' αυτό?
You mean visiting the occupied part of Cyprus as tourists? Okay.
Stop.
Did you hear the question? Okay. Okay, good.
So one of the questions that I mentioned earlier is whether third-party nationals can count as instances of violation of this norm. It seems, based on the reading of the text itself, that it requires transfers of nationals of the population of the occupying power, i.e. people who were in the occupying power first, and then they go to the occupied territory second. So people who come from a third place would not be included. However, as various organs of the international community have interpreted this in other contexts, in particular in the context of Israel, third-party nationals have been apparently, by some international declarations, included, which could potentially mean that British retirees, for example, could be part of this phenomenon, as well as students from third countries and so forth. That does seem to go entirely against the text of the provision, but there have been statements that would interpret it in that way.
Well, yes, I would not even put a big question mark on it. I mean, I think that the people who've been buying stolen land in northern Cyprus and building houses there, I think a lot are from the United Kingdom. Some of them are neighbors of mine in London. And I don't see that the International Criminal Court is going to get at that. I don't think that's the forum for it. I think this has to be about settlers coming from the mainland and being brought into the occupied, in mainland Turkey and being brought into Cyprus. The same with regard to tourists who go there. I think that's a separate problem, and it's probably in some ways better that the Green Line is open and people can go across the Green Line. Although building tourist resorts on stolen land in Kyrene is another question altogether. But this is not going to be dealt with by the International Criminal Court.
Let me just add a little bit to what Professor Shabbos said. First of all, I'd like to qualify his statement a little bit, because my understanding is that many of these third-party nationals who wind up in northern Cyprus, they do indeed come from the mainland, in the sense that there are no direct flights from Heathrow to northern Cyprus, so they have to go through Istanbul, and indeed that is where they come from, that is where they are routed from. So they are, in a sense, coming in a proximate sense from the mainland. Now, no one is talking about prosecuting these people. The question is, when the ICC is considering what's going on, is this counted as an example of the behavior? Now, it seems that the ICC does not think that people who come from third countries necessarily qualify. The example I will give, for example, is the situation of settlers in Abkhazia. So, principally, the Russian settlement enterprise in Abkhazia is a kind of repatriation or return policy, where they encourage the Abkhazian diaspora in other countries to come back and take up residence in Abkhazia, thus diluting the Georgian population. The job of encouraging those people to come back has gotten much easier, because apparently many of them live in Syria, and the Syrian civil war has made it not hard to attract people into Abkhazia. However, the complete absence of this issue from the ICC prosecutor's report on Georgia and referral on Georgia suggests that this kind of routing of people from third countries is not what it would consider a part of the crime, because it does not mention this in relation to the situation in Georgia at all.
Thank you. Yes, we have one more question. Yes, you have the floor.
Διερωτούμε, κύριε καθηγητά, αν θα μπορούσε η Ευρωπαϊκή Ένωση μέσω των επίσημων οργάνων της να προχωρήσει σε μία καταγγελία της Τουρκίας στο Διεθνές Ποινικό Δικαστήριο με την κατηγορία επικισμού σε ευρωπαϊκό έδαφος υποκατοχή.
Who wants to go first?
The only person who prosecutes at the ICC is the prosecutor. It's up to the prosecutor. Anybody can make a complaint. So the European Union, just like Professor Kantorovich, can make a complaint, can submit materials. Anybody can do that. You're all welcome to do that. It's guaranteed by Article 15, Paragraph 1 of the Rome Statute. But only the prosecutor decides actually to proceed with the prosecution. There's a small technical exception where if the prosecutor decides not to proceed, the court could order her to proceed. We don't know how that will work in practice, but I don't think that really need concern us. The point is that the EU could submit information like anyone else, but it has no special standing to provoke a prosecution.
I would say that information submitted by the EU would be taken probably quite seriously by the prosecutor. It would be hard to ignore. And I would add a little caveat to what Professor Chabas said. Any member state can make a referral to the ICC, even for crimes committed in the territory of another member state. So Cyprus can refer this situation because Cyprus is a member state. But since all of the EU countries are member states, any EU country could make the referral, though it would raise the question of why one would be more Catholic than the Pope, Cyprus being the logical location of or origin of such a referral. But indeed, short of a referral, the European Parliament could request an investigation, and that would just be treated as a complaint, though probably treated as a complaint, that has to be read and responded to.
Very well. Yes, Mr. Zonias.
Η ερώτηση απευθύνεται στον κύριο Πρέσβη. Κύριε Πρέσβη, ποια είναι κατά την άποψή σας η προστιθέμενη αξία αυτής της προσπάθειας να τεθεί το θέμα του επικισμού ενώπιον του ποινικού δικαστηρίου, συνεξετάζοντας το παράλληλα με την προσπάθεια ανεπίλυσης του κυπριακού προβλήματος?
Νομίζω τα δύο θέματα δεν σχετίζονται. Δηλαδή είναι δύο παράλληλες διαδικασίες. Η μία προσπάθεια όμως αν επιτύχει, δηλαδή ο κ. Μαυρίδης αν επιτύχει με την πρωτοβουλία του, της οποίας τη στήριξη της κυπριακής κυβέρνησης, θα βοηθήσει στην τελική επίλυση της πτυχής του επικισμού. Διότι η τελική έκβαση των συζητήσεων θα πρέπει να λάβει υπόψη αυτό το αποτέλεσμα.
Okay, very well. Anyone? Yes.
Ένα άλλο καυτό θέμα από την κατοχή στην Κύπρο είναι και το θλιβερό πρόβλημα των αγνωμένων, οι οποίοι πιστεύω είναι θύματα της εισβολής και θύματα του επικισμού. Για 41 χρόνια οι γονείς τους περιμένουν για την τύχη των παιδιών τους. Πιστεύω ότι η Τουρκία πρέπει να δώσει κάποιο λόγο και εξηγήσεις για την τύχη αυτών των παιδιών που για 41 χρόνια οι γονείς τους έχουν φύγει περισσότεροι από τη ζωή και δεν ξέρουν ακόμα για την τύχη των παιδιών τους. Συνεχίζουν οι δικοί τους να αναζητούν τα παιδιά τους και η Τουρκία πρέπει να δώσει το λόγο σε όλους αυτούς τους ανθρώπους που για 41 χρόνια υποφέρουν.
Would anyone from the professors would like to comment on the question regarding the missing people of Cyprus? Or would you like to?
Again, to reinforce what Professor Chabas said earlier, regardless of the gravity of the crime and its seriousness, the temporal jurisdiction is a significant issue. And for crimes that were committed before the entry into force of the Rome Statute, the ICC is not the address. Now, that doesn't mean there couldn't be other addresses, but in general, when dealing with the ICC, it's wise not to ask more of it than it can deliver, because the ICC gets something like 16,000 complaints every year. The vast majority of them are for things which are just outside of its temporal jurisdiction, often things which happened a long time ago, or in countries that are not members of the ICC. And it's good to focus when we're talking about the ICC on what they can do and take other issues to other fora.
If I could just add, perhaps we should have spoken to this earlier when we talked about the possible crimes that could be addressed by the International Criminal Court, because enforced disappearance is listed as a crime against humanity. And it raises, in principle, difficult issues about the temporal scope, because as long as someone, when the enforced disappearance takes place, as long as it's still unknown the fate of the person who has disappeared, there's an ongoing violation. And that's, of course, what the European Court of Human Rights said in the Varnava case and in other cases. So that's well recognized in the context of human rights in the European Court of Human Rights. When the Rome Statute was adopted, the member states agreed, Cyprus would have been one of them, Cyprus would have been at the meeting, that in the definition of enforced disappearance, there's a requirement that the attack that leads to the forced disappearance took place after the entry into force of the statute. So it seems pretty clear we're talking, if the starting point of the enforced disappearance happened prior to the 1st of July 2002, then it cannot be addressed by the International Criminal Court. So that's the legal answer, and the solution is that those issues have to be taken up elsewhere in places like the European Court of Human Rights.
Very well. Okay, let's have the last round now, because we have about 10 minutes. Let's see, anyone? Okay. All right. Well, let me just say a very short comment as a closing remark. This has been indeed an enlightening and interesting discussion, not only for Cyprus. Cyprus is the case that we discuss, but as a member of the European Parliament, I could say that we can take it further, because Cyprus issue, it's also a European issue, and we are all concerned as European citizens, especially those of us who happen to be members of the European Parliament. We are concerned with the values and principles of the European Union and the rule of law. And the ICC, the International Criminal Court justice system, it's part of this justice system of the European Union. Thank you very much, Professor Shabazz, Professor Kondorovic, and Ambassador Corneliou, for all your contribution, and we will keep you informed for any further steps. Thank everyone for being here today, and all the viewers and listeners across the globe. Thank you.